Greetings. How are you doing, everybody? This is a video that I'm gonna make available for the premium members. Y'all see me do videos about this before. I'm calling it the mortgage blueprint, if you will. This actual PDF file that you're looking at on the screen here, all of these are hot linked in as always, and I'm gonna make it available for the premium members of thctrust.org. If you want to join our organization as a premium member, you can donate $24 per month to thctrust.org. Visit the website www.thctrust.org. That's how you can get access to these things. There's a regular registration, which gives you free access to a lot of the pages and things. And then you can donate the $24 per month. That gives you the access to the majority of the templates on the website. The master file, which deals with status correction and commerce, that is a $150 donation. That's a separate thing entirely. I may work on merging those together, but I'm still working on the new website right now that's not complete yet. So we'll cross that bridge when we get to it. So just to summarize, $24 per month is the membership that gives you access to things like this and all the templates that we discussed today. And we're definitely not going through all of this. This is completely populated. Everything in here is something that I've done or am doing or whatever. Actually, I have to put this in here for instructional purposes only. This was a Treasury Direct discharge that I had attempted to do for a mortgage. And what happened is they basically responded and said that although, and they actually said this, although they do what they say deposit United States securities notes and all these other things, they basically said I need to direct my communications over to the IRS. That is exactly what they said. So I put attempted here, but this is not complete because I still gotta do some things with that. And maybe if you have some of these statutes or you know where they are, you can send them to me. But I have this feeling that I need to do some more research, because I believe if you give something to an agency, like an agency of the Treasury, such as the Bureau of Fiscal Services, which is, they administer a lot of things for Treasury Direct. The IRS is a agency of the Treasury. All these different departments of the Treasury, I believe if you give it to the wrong department, they're supposed to internally route it to the correct department. So just to give you some insight to how I operate, I don't always take the first no for an answer. I look into it, I see if what they're saying is sound. And if not, I'm going to communicate back with them and say, well, I need you to facilitate getting this to the correct department, right? But not to get off the subject, I only want to put out some specific things in this video, make it real quick. First off, if you're using this as a resource or a tool, there's a lot of different things in here. You have to make sure that you draft your own personal blueprint based off of how you're dealing with the situation that's before you, and then you go in here and you grab the pieces that might be resourceful or that you can add to your own research. So out of all these things in here, there's discharge processes, right? Here's an example of one that I did, a discharge debt with the CFO process. I'll probably discuss that in the next video after this. But just so you know how this works, as always, you can click this here. So I click in it, and what will happen is it's popping up in a new window on my computer here, but on your computer, it'll probably download and pop up as a PDF, or it may show up as a new window. But if you're on a smart device, like if you're on like a cell phone, it might not show up, or it may or may not show up. So just so you know, most of these links are PDFs. When you're looking at any of my outlines and you see something, for example, such as this, when you see something with document after it, that means this is the PDF and document is the Word document that you can download. So this is an appointment of someone as a paying agent. You can click this, it's a PDF. You can see, okay, here's a template of the PDF. But if you just wanted to go, let's say, to the document version, you'll click this. I don't want to click it because I don't want it to download. But it'll just download the document on my desktop so I can edit it. So just pay attention to that. And there's a bunch of things in here. So I said there's a discharge process, a discharge debt process that you could do with a CFO if you are competent enough to do that. Here's the example We just looked at my example right here. It's not just one page. You're looking at the financing statement here. You're looking at a W-8, which has its purpose. So you can backward study this. This was done. You know what I'm saying? This is the real deal. I did this. Right? So anyways, that's what it is. You know what I'm saying? But what I want to talk about in here today is a potential area of remedy in these mortgage situations, and listen very closely and share this with your group of people who studying this. And if you find something good in here, um, share with me whatever you have that's good, that's relevant, and right along these lines. Excuse this weird freaking animal next door. It was really irking me, making all these weird ass noises. It's one of these weird ass Chihuahua dogs or whatever. Anyway, so what I want to talk about today is something that I'm looking at that's a potential remedy. Let me see if I can pull up a promissory note. Where can I pull up a promissory note? I think I have. Okay, maybe it's here. Let's see. All right. Unfortunately, I don't have it here, but the first part of our process is registering an affidavit of beneficial ownership, affidavit of title on the principal interest in the promissory note. Why? Because we are the original maker, issuer, grantor of all the trust instruments involving those transactions. But grantor, maker, issuer of the note is a financial asset that was invested, undisclosed to us, etc., etc. Now, something about that asset. I realize that there's a servicing industry, which we're pretty much familiar with. That's probably your bank or whoever you're dealing with the foreclosure type of situation. That's your servicer. It might be, ABC Banking Services Company, whatever. I think we all know what a servicer is, okay? When you deal with your servicer, you're usually using verbiage like, if you were to call them right now, they will say, what's your loan number? Whatever they'll say, you will end up giving them what I believe is properly referred to as your note number. And I'm making a distinction here because usually the numbers that we're familiar with when we're dealing with our mortgage is the note number as opposed to the loan number. So I'm trying to draw a distinction between the note that deals with your mortgage and the actual loan. And these are usually two separate numbers. And what I want to express to you, what I'm finding is that the loan number or whatever represents the loan number is usually the type of number that's being tracked on the federal government side, whether it's Department of Veterans Affairs, Ginnie Mae, Fannie Mae, Rural Development, Department of Agriculture. Just understand that they're usually dealing not necessarily with a loan number, but not a note number. The note number being what the banking and service industry is dealing with when they're servicing a loan for their principal, which is the government, but actually you're the principal maker issuer of the instrument. So the government is your agent, the servicer is the agent for the government, which is their principal. And this is important because I was learning in these types of agency relationships that the servicer as an agent for their principal, which is the government, which handed them the assignment or which really holds the loan or owns the loan or however you want to put it, the agent doesn't have any obligation to you in your capacity as a beneficiary to whatever extent you are a beneficiary. And to some extent you are the beneficiary, and the government kind of knows that, and that's why they keep one arm away from you, because really they're acting as the trustee. And there is a relationship between the beneficiary compelling the trustee to perform. So they put an agent or a servicing agent in between because the servicing agent really has no obligation to the beneficiary. You know what I'm saying? So, it's almost like a safe move for them. So you are going to find out if you start to deal with HUD or Department of Veterans Affairs or any of the government side of this mortgage situation, and the government side that is actually holding the insurance for these contracts, the insurance that your attorney is trying to collect upon outside of what he's trying to do in court with the foreclosure and take the property and all of that. He's behind the scenes interfacing with the Department of Agriculture, or excuse me, Rural Development in your local state, because they have one in each state. And I believe they're going there, and that's where they're doing a lot of the business. And if you try to go through those same doors, the first questions they're going to be asking you is, are you an attorney? Are you this? They're going to stiff arm you. If you try to go through those doors as John Doe, my mortgage, whatever, it's not going to happen. So what does that mean for you? I don't know what it means for you, but I know what it would mean for me. If I was on the other side receiving this conversation and I felt like I wanted to make those calls, I would be such and such attorney from, such and such receivership trust, court appointed trust. I'm trying to figure out some information. I can fax you a copy of the appointment letter that I've been appointed as receiver if you would like. Push comes to shove, I probably just I don't think they will ask for all that. But and then another thing is I think that if you're going in there and you start quoting loan numbers, they're gonna kind of know that maybe you're not the type of person we want to be sharing this type of information with. So that's if you say, excuse me, note numbers. I want a distinction. When I'm making the distinction, the note number is what the servicer has. But when they're dealing with the government, trying to collect on that insurance money, because that's what your attorneys, your foreclosing attorneys are doing. They are billing they're billing your entitlement, and they're billing the government who's insuring the notes, usually through some government program. This is why HUD is always going back to HUD. Because they're by some kind of way, by them buying out these insurance contracts, they're offering to buy out any type of promissory note. They're offering to buy the insurance from whoever's privately insuring it now. And in some cases, whoever went bankrupt, they went in and bought it out. And in other cases, they're offering to buy out promissory notes. So they're doing everything to take a security interest in the whole shebang, as they should, because it's the government's obligation at the end of the day. So there's a reason why I've said all this to this point, and now I'm going to move on to the next part of what I'm going to just talk about. But but you have to understand this first to see where I'm looking at this potential remedy. I kind of stumbled across learning this, assisting, a family member with their mortgage situation, which was a Veterans Affairs loan, and I was able to, the way that I'm very diligent and relentless in my approach, I was able to create a situation to where now I am directly communicating with somebody on the insurance side, right? And I'm communicating with the attorneys and communicating with the actual servicer, all on an email string, introducing them all and asserting who I am, my entitlement as the trustee under appointment, and all these different things. But the point is this. This is what I found. When I was trying to think about this, I said, many of us have fought so many different ways in these courts, and we're not finding the type of remedies that we would like to find in court. Sometimes we're finding estoppels. We're definitely not getting orders and things done. We're not getting orders in our favor. So we have to do everything that we can to correct the record, whether on the county level, whether on the federal level. So let me make the distinction. That's why I kept saying know the loan number as opposed to just the note number. Know how they're tracking it and where they're tracking it, because there's the Code of Federal Regulations, and there's a whole separate set of laws that apply to servicing and handling that contract on the federal government side. Usually a lot of us are oblivious to this because we're approaching it dealing with the bank and going back and forth and looking at the local court for a remedy. Whereas meanwhile, you don't know behind the scenes that there is a very strong relationship between the government and your actual servicing bank. A relationship where it's almost they're getting the ultimate okay and the authority from the government office, whether that be HUD or VA or whatever. And so I started to look and say, well, where is the remedy? I'm not going to be looking in the statutes and all these local things in the court where it doesn't seem like things are failing. So then I started getting into the guarantee. And let me pull these up. And this is just something simple that I found, but I want to share it with you guys. And if it's necessary for you because of your situation, exploit the opportunity. So what I found, and I'm going to have these notes available with this video. Again, all these templates and everything is available for premium members at THC Trust. They're actually available for members of THCTrust.org that are paying their dues of $24 a month. Anyways, all this yellow stuff right here, you can Google under 38 USC, and I think it's actually, 38 USC 3712. Or you could just, you'll get these notes, and it's in here. That's, I want to say it's under the Title 36 CFR 2. This is talking about the guarantee or the certificate of guarantee, the loan insurance, right? Because again, what happens is there's a financial asset when you sign that note. You didn't know about all that, but the financial asset, some may say gifted, pledged, whatever, it had value and it was invested, and there was misrepresentation made to you that you were receiving a loan from bank capital. In reality, no such consideration was provided. You just took on a liability while your financial asset was invested. And the bad part about it is with that, even now while we're making this video, we have never got full disclosure of this fact. So you still don't even know what you're entitled to, but you're still being made to perform under this contract. And that's why we do the rescission as first things. And y'all know, y'all seen the rescission before. But the point that I'm getting at is that you have to understand that what happened to that financial asset. Well, but by what I see, and I'm not saying that it all happened like this, but this is the way that operationally it's going down right now. I guess what I'm trying to say is it looks like this mortgage thing happened so quick with the boom. It was so quick that nobody knew what was going on. And now there has been a lot of restructuring with the federal government and the servicing industry in regards to who's holding certain instruments, who's holding certain title and interest, who's assigning it. And this deal with MERS, the federal government, the guarantee, why they're buying out the insurance and why they put these little agencies in place, because they're trying to, it seems as if they're trying to restructure and repair a whole faulty system in the first place, where the way they rolled these loans out, that which were investments, and they never gave you disclosure, so you're just losing your whole security entitlement. Meanwhile, when you talk to these people, and you would know this because you don't usually talk to them, I've been talking to them, they actually call it an entitlement. From what I understand, your guarantee or your insurance that insures the note that they are investing in a trust, making money off of, the principal is where your security, that's your security entitlement. They're holding on to it. They call it an entitlement. That's the verbiage and the terms that they use. This is why our first thing is the affidavit of beneficial ownership on our principal interest. We're claiming title of our title and trust, and we're assigning a trustee at the same time, right? And we're destroying the agency relationship between us and the government, because where a trust exists, there can be no agency relationship. It's just the operation of law thing, which is why we need to operate in trust. But to get to the point, this deals, everything in the yellow deals with Veterans Affairs loans. So you can click these notes, you can Google and find this stuff yourself. The most important thing that I want to show in here is these are basically written for the servicing industry. This is what the government, the insurers of these loans, have written towards the servicer industry. And I was looking at this because I figured out there's a connection between these servicers running up in the court and foreclosing on people. It seems to me, based off of my experience, some kind of way indirectly, they get the okay, the permission, or the incentive from the federal government first. So what I'm looking at is you kill the problem right there. And those are the people who's obligated to discharge the debt when you do the appropriate procedure for discharge. You present the correct instrument and instructions. They are required to do it. So they try to stay the most arm distance away from you and duck. Now, I'm going to tell you, one of the things that messed this up is there was a brother by the name of Brett Jones redress. Y'all remember one day, not one day, but back about maybe 4 years ago, he was dropping this information about the Department of Agriculture and Rural Development and how they were holding the notes and all this thing. But I think what messed things up is he was putting their telephone number on the internet saying, yeah, call Sally, ask her. And at that point, after that started happening, there's no more communication with you. So you're going to have a hard time getting that directly from them. However, this is what your FOIA requests are for. There's a bunch of FOIA request templates on thttrust.org under the public officers and the information tabs. So you can hit those FOIA requests. You can get these informations. Now, but just be savvy. So what do you want to know? You want to know that government number. You want to know, is it Rural Development, Department of Agriculture? Then when you find these places, you want to know who those officers are, the directors over there. Because if you're going to be doing private processes and presentments and things like that, you have to make sure it's going to someone entitled who has to enforce these things. Government officers, they are definitely held, they can't just oppose federal laws, right? So you're giving it to them and you're hitting them with the federal statutes at large, which is the positive laws enacted by Congress. And I'm going to be honest with you, I've spoken to a couple of government people, and it's becoming very apparent, some that have actually retired from the government, and they confirmed that a lot of them know that there's some legitimacy to the things that you're doing, but they know that they don't have the proper training and they're not spun up and they're not caught up. So that's one of the reasons why I try to remain so meticulous and put references for everything I'm doing, because I know that my intention was to teach myself. Now I'm out here teaching y'all a little bit, and they're subscribed in, learning stuff too. And my end of the day is just don't interfere with what I'm doing. But anyways, to get to the point and wrap this up, what they have said to the servicers, that if misrepresentation, although material, is not made, let's back it up. They basically said there shall be no guarantee liability on the part of the secretary. They're basically saying we ain't paying out no insurance claims in respect to any loan as to which a signature to the note, the mortgage, or the other security instrument is a forgery. If you don't know about the forgery, look up the other video. Did I talk about this yet? I did. I know I talked about this in another video. So go look back a couple other videos. Forgery is a true signature written on a document with false pretenses. So I showed about that on the VA side. Damn, I think I'm repeating myself. I already did this video, I think. I did do this video. Okay, well, cool. But there were some other things that I didn't show. Anyways, this is what I didn't show you. I know why we talked about forgery, but let me go all the way in, because these are federal. This is what I'm trying to say. These are federal laws. If you ever know government employees, they don't break federal laws. That's how you have to put people. You have to use these statutes to pin people up against the wall and make them do what they are required to do. This says that if there is forgery involved, it says, let me read it. There shall be no guarantee liability on the part of the secretary in respect to any loan as to which a signature to the note, the mortgage, or other security instrument is a forgery. So you have to know the broad definition of forgery. Right now, go to Google, pause this, go to Google, type in Bouvier's Law Dictionary, and go to F and read all the definitions of forgery so that you can understand the multiplicity of things that constitute forgery, and then make the determination whether there's forgery on your note, mortgage, or any other security instrument. Because affidavits within the federal government's perception, they have to be rebutted. So you can do affidavits of forgery if you can qualify that such thing occurred. But you have to know what those definitions are first. Let's continue to read. Except as to the holder who acquired the loan instrument before maturity for value and without notice, and who was not directly or by agent participated in the fraud. So now it's telling you fraud too. And as long as the person had, they're basically saying you can't collect on this if by agent or directly related, or even by agency, you participated in the fraud, right? This is why you have to give them all of these notices and give them the proper time to respond. Now, another thing is why I would suggest you have to be very strategic It says if that person was directly or indirectly involved in a fraud. Now, if you realize that they're never answering your affidavits, they're never responding anyway, you have to hit them with the proper affidavit that constitutes their consent to the facts that they are not overlooking, that they are straight misrepresenting, that they're willfully and intentionally making material misrepresentations and fraud. So you have to. So what I am suggesting to you is that when you know that, for example, let me tell you what I've done. When you know that VA is guaranteeing the loan, and this is a VA code right here, and VA is ignoring, and they're trying to streamline you and roll over you and foreclose along with the fraud of the industry. You start putting affidavits of specific uh, affidavits of fraud, forgery, specifically in the hands of the specific officers who are on your account. This is why I'm saying know your account, know who's holding it, know who's the officer over that department. You start putting this in their hands with the proper O&B forms and FOIA requests saying, what is your procedure for me to report this? What can I expect from your office as a response to this, or as far as an investigation? What can I expect? How will you guys look into this? What response can I expect? Right? Look into what? So you got to hit them with these affidavits of fraud and forgery, and then put it at the Treasury where they need to go to collect. Make sure their names are in it so that they cannot act like they are a holder who acquired the loan instrument before maturity for value without notice. So start giving them notice that they do have notice. So if they keep proceeding beyond the notice, you put their names in it individually and the corporate vessel that they're operating through, and you perform very precise affidavits with tacit acquiescence clauses that if they don't respond, when they don't respond, because they're not going to respond to the fact that you had no knowledge of the underlying financial transactions, nor the investments that were created off of the financial asset that you pledged. You were under the assumption that the bank was lending you capital. They are not going to respond to that. Why? I don't want to get off the subject dealing with why. The people who are really adept in their research, it goes without saying they're not going to respond to it because they'll be committing perjury on the record. There's no way to respond to that. It's fact. It's the truth. You see what I'm saying? So anyway, so you got to put it where it matters. Now, again, this is the VA side. Now you can scroll down to the bottom of these notes right here, and I'm going to show you where it says the same thing. Here it is right here. Loss of guarantee for fraud. This is under rural development. This is why you have to get on the government side, because when I say the government side, my research is that when you start tracking your promissory note, whether it's Fannie Mae, Ginnie Mae, Freddie Mac, with the exception of the Department of Veterans Affairs loans, I think they all lead back. I'm pretty sure that they all lead back to rural development. And I am not sure, but I think the intention is to buy out all the real estate loans and have them insured by the government in the United States. So it all goes back to here. Let's click this right here. Let's look at this. So I just showed you that highlighted stuff was the VA side. This says the same thing, reducing or denying the claim. And this tells the reasons why rural development, the one who's ultimately holding the insurance, I believe for your promissory note, which is who these banks are checking with beforehand before they run you into the court. See, a lot of times the court procedure is a part of the paperwork that they have to submit to rural development to collect on that insurance money. And then sometimes the non-judicial states, it's that 90-day foreclosure paperwork that they keep mailing you back and forth. That's their so-called due process. And a lot of times they are committing fraud by not indexing and recording your responses. They're just trying to get through this paperwork stack so they can turn it in with all the perfect paperwork so they can cut a check from your insurance money. So I have not necessarily figured out why it appears that when you stop it here, you stop it in court and everything else. But that seems to be the case, and I welcome your insight. But when you read this, it says this is why. Failure, it says committing fraud or failing to report knowledge of fraud or false information. What happens when they're not ledgering payments that are marked deposit to the United States Treasury? See, I didn't go into Title 18, but this goes all into Title 18, but we're not trying to go into that. I'm just trying to show you directly where you have to look at where your loan is on the government side and get that information in there if there's fraud. What information are you talking about? What information am I talking about? Well, I went through that in another video. You got to go watch these other videos, but I talked about it. Let's click on it again down here. A couple resources for that. For example, here's one that I just did. Breach of trust. This is after I did a discharge presentment and everybody went silent. So I did a discharge presentment to the CFO. They didn't send no bills. They didn't make no telephone calls. They didn't give no acknowledgement. They didn't send back the change. They just went silent. So you got to keep going and pounding on them. What is this right here? This is not the right document. Let's get to the right document. This is the right document. So what I said is why they were silent, you kept on going. So, right, here's an example. The principal, trustee, I'm operating as the trustee, the respondent, the servicing company, carbon copy, the government. That's just the way that I'm doing it, right? Notice I got different numbers here. There's a loan number, that's the government number. There's a note number, servicer number. And then there's a guarantee number. That's a different government number. That's a United States number, the certificate of guarantee number. Now, consequently, on that note, let me show you something real quick while it's crossing my mind. So I showed you where these laws were down here that showed you the loss of guarantee, right? It's talking about insurance, collecting on the guarantee. This is insured notes. So you should go with the presumption that your note is insured. Now, what I would suggest to you is first that you'll get a copy of your promissory note. Usually they don't give it to you by default, but if you get your hands on a copy, usually if they're trying to foreclose on you and you write the attorney a letter asking them for a true copy of all the instruments and all of that, you'll get a copy of the promissory note. So you already know your mortgage number or your note number, I think. So when you look at your promissory note and you see some other identifying numbers on there, know that those are going to probably be the numbers that link you into where this thing is on the government side. And when I say where it is, don't think it's like I got to know exactly where it is. No, you start tracking this as far as you can get it. Then you go to who the officer is of that organization, or loan officer, or somebody that's insured over there, someone who's required, who cannot say, I'm not going to follow the United States federal laws. You go to somebody who's required to perform, that's in the chain of doing business on your estate. Obviously, you have to go there operating in trust. There's got to be evidence of the trust. And this is why before we even got here, the first thing is we filed the UCC1 financing statement on the note and the whole matter. But what I was going to say is you can use the FOIA requests. When you know the government office, shoot them a FOIA request with all the information you can to identify your loan note and ask them for proof of the guarantee, a certification of the guarantee. Listen to my words because I know you're not going to remember what to ask for. Ask them for a certification of the guarantee as required per blah. And then hit this statute right here and cite it out. This request is pursuant to Freedom of Information Act as regards to give them enough information to identify what they're looking for, because you may have to do it that way because a lot of you will not get through one of the telephones when you call these places. So then you can do it there. You can do it there. If you do this to VA, they're going to send you a certificate of guarantee. It's going to actually be a certificate, and they're going to tell you to, I'm going to give you an example. Where is it at here? We did this. Oh, I don't have it on here. But they send you a certificate. You got to mark it paid in full and endorse it, right? So anyways, so I showed you how, so you want to get that promissory note, track these numbers. Why? Now, this is why. We just basically said why. But the first thing I wanted to show you was this breach of trust document. Let me just read through it real quick. This is actual and constructive notice of a breach of trust and the ongoing breach of fiduciary duty by the respondent ABC Bank through its office or whatever on the basis of intentional acts and omissions of the respondent's duties to report, account, and disclose of terms, conditions, and interest and entitlement in the chattels relating to accounts, and I list all the account numbers, including the security deed now rescinded as of June 4th, 2015, recorded in the books of Liberty County and book number, page number, whatever, right? Just laying out the scenario. The principal, right? The principal is the person who I'm acting as the trustee for under appointment because all his affairs have been mismanaged to this point. The principal is the grantor and or beneficiary of the trust originally created by the principal's signature, authorizing and authenticating the deeds, notes, and all chattels arising therefrom, and held under the trusteeship of the Department of Veterans Affairs and their agent, ABC Bank National Association, blah, blah, blah. The first grounds upon which this notice of breach of trust is given arises from the respondent's willful concealing material facts and misrepresenting the terms of the contracts for the purpose of deceiving the beneficiary by concealing material facts regarding the principal's rights, title, and interest held in trust. I think I can word that a little better. Basically, I'm saying you're not telling me that you're holding investment property, a financial asset, and that there was no consideration, and you have me as a surety under a contract. I already put a claim of title, affidavit of title, W8, claim of beneficial interest of a foreign trust, right? I already put all these claims of title on it, and you're still misrepresenting the facts. And it might be cool, but at the end of the day, it's not really cool because you can't misrepresent the facts and expect me to keep performing. That's just absurd when you really think about it. We have to really have a renewing of our thought process. Many of you will pay off your mortgage in 15 and 30 years and you don't know or even feel that you're entitled to anything else. You know what I'm saying? That's crazy. What are you getting out of it? But anyways, back on the subject, the first grounds was that breach of trust. The second grounds upon which this notice is given results from the respondent omitting to credit the principal's payment to settle the alleged outstanding debt obligation of the respondent for the sum of $51,000, blah, blah, blah. That's because I did the discharge process, right? Then they went stone cold silent on me, as they will. The discharge process is a monster. They went silent on me because there was nothing they can say. They were straight either going to have to do what they were required to do, or they were going to violate federal laws and all the laws and violate the federal laws, the local laws, the statutes, fiduciaries, breach the trust. You do all of that. You know, they was going to have to do all of that. Why? Because I did my research. I wasn't looking for somebody's A4V process on the internet. What I've done was backed by thorough research. So they're not going to respond to this breach of trust because it's the truth. And if they do, it's good. I need to hear what they say. But notice here, there's two things here. There's this breach of trust, but then there's also an affidavit of John Doe regarding dishonesty and fraud. And this affidavit of John Doe was where I'm straight affidavit mode, breaking down the fact that there was fraud, misrepresentation, concealing of material facts. I did not know that I was pledging a financial asset. I did not receive disclosure of my rights, title, and interest in that asset at no time that's where all that affidavit is laid out that they won't respond to. It's a cold affidavit. It's the coldest affidavit I've ever seen in my life. And I must admit that I didn't write it. Somebody else wrote it. I don't know who wrote it. And it came over. And since I'm about, getting this shit right, it's right here. But anyways, there was the breach of trust. Where was that affidavit I'm talking about? Oh, it's down here. The affidavit of fraud, right? So the affidavit of fraud is there. Remember, because you want to index these things in the right place, because they have to be responded to. Notice it's coming from the trust. The principal is John Doe, in care of a notary public. Why did I put a notary public? Because they got to respond to that notary public, right? Respondent ABC Trust, dishonesty and fraud. And it breaks everything down. It's a self-executing contract, right? Go in there and read it on your own time. Okay, now, what else? Now, so I hit him with the breach of trust, and then I hit him with the affidavit of fraud. The breach of trust is just a notice. I've given you notice. I've given you notice of the breach of trust. I've given you the notice of the breach of your fiduciary obligation. Why? Because you haven't given me full disclosure. And even when I gave you a proper instrument, you've concealed material evidence from the record. You did all kind of stuff in Title 18. I didn't have the time to go through that yet. Title 18, they nailed that one. But this is just a notice of the removal of the trustee and the revocation of the trust powers. Down here at the bottom, the last thing it says, under the powers inherent in myself, having the controlling status as the grantor, I hereby revoke all powers, authorization, authority, consent, and powers of attorney previously donated, granted, conveyed, assigned, and or vested with or to the respondents. This cancellation with regards to any, so you see what's going on there. Absolutely, it applies to absolutely any real or alleged agents, contractors, officers, employees. So you see what's going on there. Revoke that power of attorney. So I revoked the power of attorney and I gave them the opportunity to respond to this notice, but the basis upon which this notice was given, like how they do a motion in the court, there's an affidavit in support. This affidavit is in support of this notice. No one's going to touch that affidavit. So they got a problem on their hands. And while they are figuring out that problem, I like this form right here that I guarantee you're not going to find it. I promise you guys, the day that I pulled this form off the internet, the next day it was gone. Why? Why would they do that? Why? Why would the form be there one day and gone the next day? Well, you can make your own determinations. Let's talk about the form real quick. What am I talking about? This is an OMB form. I found this form while I was trotting through, and I showed you this form before. It's a FS form 0974. It's a Treasury form. The Treasury is Bureau of Fiscal Services form. It's affidavit of forgery for security, right? All of these things are security. You can identify the security by numbers and everything else and all these other things. OMB. What is the office of OMB? They're a very high office. They're a very high office. Everybody else follows suits. They can't duck these. These is for custodians and information reporters. They can't just duck these and ignore these. So if you're using OMB forms, I suggest you use certified mail to make them legal presentments, if you will, and know exactly who you're giving the OMB form to, and make sure they know that they're getting it. In the case of certain organizations, sometimes you may not be able to give it to a specific person, but if you can, like I say, that's why you want to know who these officers and things are. This is an OMB form. You identify the title of the security, such as if it was a note or an adjustable rate note, the issue date, the date it was issued, the face amount, the amount on the face of the instrument, the identifying number. I would probably use a loan number and a note number and a, what's the other number? A CUSIP number, right? Because that's the proof that it's been traded and stolen. It's stolen once you ask for your security entitlement and they look at you like you're stupid, like you're not the maker and the issuer. That's when you're like, okay, I see what's going on. And there's still all the other suspicious activity report, IRS forms, and all these other forms that can go with this. But I suggest you be strategic if you use this, if you know what you're talking about. And when you get it into these government offices, don't run off like a sovereign citizen. Be cordial and meek and ask them, okay, I submitted these forms to you because I read in your laws that fraud and forgery is a no-go, and I've documented it right here. How long will it be before I can expect a response? And if you can't answer that for me, give me a call. Have your supervisor, one of your officers, let me know what action you guys intend to take and what I can expect, because some kind of way I have to be able to report this as a whistleblower or whatever. I don't know. We get creative, but don't run from what you've done. Stand in there and orchestrate it. Make it go down. Registration. You might put your UCC registration. You know what I'm saying? Figure it out. But this thing has to have a medallion stamp on it. They're telling you right here. Now, unlike most OMB forms, they are PDFs. I don't know why this one is a Word document. And again, if you want to look for this, if you find this form, send it back to me. I can't find it online anymore. You know what I'm saying? The day after I downloaded it, it was made invisible. It's gone. It's OMB 1530-0040. All right. So that was another tool, and we see why we're using these because, on those affidavits and on those forms that are not rebutted that need to get indexed in federal records, there can be names of the individuals involved in a fraud, names of the companies, because as it says here, if they are one of the parties to it, you can't say you're not one of the parties to it when your name is in the affidavit on the record. All right, so those were just some things that you can consider. You know what I'm saying? Of course, when we did the revocation of trust powers, I just talked about that. Then you would come back down here. You got to go here. You got to go here with it, right? Because reconveyance, assignment of trust deeds. If you revoke a trustee, you got to appoint a trustee. Let's see. Here's a document, appointment of a trustee. So that's coming up somewhere. Let's see. Is that in there? taking a while. Okay, certificate of appointment of trustee. It's a trust certificate. There you go. Here's a simple way of doing it for appointing a new trustee, right? I would also say, what else we got there that you can do? And then these, I put these in here the other day. We talked about this before, but we're going in some more on it. Okay. And these are just out the California Recording and Indexing Manual. Talked about that in another video. But what are these for? This tells you everything that needs to be in a deed. This shows you how they're indexing. This is important. So this is what a recorder is taking into consideration when you hand them a document. They're saying, okay, I see the names of the assigner in there. That's the party 1. I see the name of the assignee. That's the party 2. Recording reference to interest. That's the description, identification of interest and assigned. Yeah, recording reference to interest. So this is I guess if there was a cross reference or whatever, the original asset that's being assigned. So this is an assignment instrument. You can assign the deeds, but this tells you everything that needs to be in there: the fees, the citations of authority, which you may or may not have to cite. There's assignment of a deed of trust, right? This is one we may use because we revoke the trust deed powers. We revoke the deed. We may use the assignment of a deed of trust. We may use a modification of the deed of trust. You'd be creative. There's a modification of a deed of trust. This is again why I said you had to get that indexing manual, maybe using a FOIA request in your state. Notice of rescission of trustee's deed. Look at that right there, man. Grant of lien. Anyways, all these tools and resources that we thought was helpful for you is here in the master file. Templates will be made available. And also for premium members, if you need to file a lawsuit, you need a resource, a paralegal. They do cost, but I do know some paralegals that can draft quiet title actions. They can draft lawsuits, and they're very fair. They're inexpensive. They won't cost you as much as an attorney. So if you need that information and you're one of the premium members, this is a service for premium members. Contact me, coaching@thctrust.org. All right, I'm gonna check up out of here. That was a good long video. Go through this now. I can do coaching sessions on some of this. Let's see. Let's look at this really briefly. No, we'll keep it at this for now. I'm kind of tired out. Done a lot here, folks. Thank you for watching.